Hello, I am Evan Wolfson, founder and president of Freedom to Marry, the campaign to win marriage nationwide in the United States. We have now completed our mission in the United States, but I'm honored to be invited to give a statement now as you consider the freedom to marry in Colombia. Countries like Colombia and the United States share a commitment to the rule of law, to democratic governance, to equality of all under the law, to basic human rights. And all of these central constitutional values of both Colombia and the United States require ending the exclusion of loving and committed gay couples from the freedom to marry. Gay couples share the same desire, the same need for the freedom to marry as any other committed couples, for reasons that are both tangible and intangible: the protections, the meaning, the security, the dignity, the basic respect, and the responsibilities that marriage entails in both of our systems. For these reasons, the United States has ended the exclusion of gay couples from marriage, and what we're seeing across the United States is families helped and no one hurt. The same constitutional values, the same central human rights values apply in Colombia, and it is time that Colombia, like 21 countries around the globe, end the denial of the freedom to marry to gay couples living in Colombia as well. In the 2-year period between June 26, 2013 and June 26, 2015, this year, both days in which the U.S. Supreme Court made important rulings on the freedom to marry, 70 courts throughout the United States affirmed the freedom to marry for gay couples, with only the smallest handful going the other direction. Courts at the federal level as well as state, courts at the appellate level as well as trial, courts consisting of judges appointed by Democratic governors and presidents as well as Republican presidents and governors, all ruled in favor of the freedom to marry, having weighed the arguments on both sides. This huge preponderance of judges and courts ruling in favor of the freedom to marry reflects the fact that there is no good reason in a constitutional system for denying gay couples a central human right, such as the freedom to marry, and for denying gay couples the guarantee of equal protection under the law, the assurance that a minority will be treated on the same footing with the majority. The courts reviewed all the evidence and all the arguments put forward and found that there is no good reason, no sufficient justification for excluding this group of citizens from the central guarantee of the freedom to marry, the ability to pursue happiness and shape a life with equality under the law. The court here now has before it these arguments and the evidence of the kind that the United States Supreme Court weighed and found in favor of the freedom to marry, found in favor of equal treatment of gay couples under the law. I won't rehearse them here, but what I would like to use my statement time to do is to underscore the importance of the court now reaching this decision, the role of the court in a constitutional republic such as Colombia, such as the United States, is to not force citizens to go through lengthy debates or win the up or down approval of their fellow citizens, but instead to affirm and guarantee basic rights, basic freedoms, such as the freedom to marry. To force couples, to force families to struggle to try to get the permission of their fellow citizens is a violation of what a constitutional republic guarantees to all of us: certain basic inalienable rights safeguarded under the Constitution, regardless of transient minorities or temporary passions or prejudices. Justice Kennedy, in his majority opinion in Obergefell, the ruling in the United States here in favor of the freedom to marry roughly a month ago, addressed this point with great strength. What Justice Kennedy wrote on behalf of the majority of the United States Supreme Court speaks to the role of the courts in countries like Colombia and the United States committed to the rule of law. Justice Kennedy wrote, and I quote, "The dynamic of our constitutional system is that individuals need not await legislative action before asserting a fundamental right. The nation's courts are open to injured individuals who come to them to vindicate their own direct personal stake in our basic charter. An individual can invoke a right to constitutional protection when he or she is harmed, even if the broader public disagrees and even if the legislature refuses to act. Justice Kennedy continued, "The idea of the Constitution was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. This is why fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. It is of no moment," the United States Supreme Court held a month ago, "whether advocates of same-sex marriage now enjoy or lack momentum in the democratic process. The issue before the court here is the legal question whether the Constitution protects the right of same-sex couples to marry." Close quote. With these words, Justice Kennedy and a majority of the United States Supreme Court found that arguments for quote-unquote caution, for quote-unquote delay, for quote-unquote the democratic process to have an up or down vote on whether some citizens are able to share equally in the guarantees afforded to others is not appropriate. What is appropriate, the United States Supreme Court correctly held, is for the government and the law in societies like the United States and like Colombia to treat everyone equally and to not allow the withholding of a precious and important fundamental freedom, such as the freedom to marry, unless the government can show a sufficient, a compelling, a serious and narrowly tailored reason and need. No such reason, no such need exists here in the United States, and no such reason, no such need exists in Colombia. When there is no such reason or need shown for denying something important to a group of citizens, it is the duty of a constitutional court to affirm the guarantee made in the Constitution and to make sure it is provided to all citizens, including now the citizens standing before this honorable court in Colombia seeking the freedom to marry. I mentioned earlier that about 70 courts in just the last 2 years alone here in the United States weighed the evidence, listened to the arguments, and ruled in favor of the couple seeking the freedom to marry. Of all those 70 court rulings, including the United States Supreme Court ruling a month ago, perhaps the most powerful language came in the decision in Utah, in which a federal district court judge in that relatively conservative U.S. state affirmed the freedom to marry and said that it could no longer be denied, no matter what the majority may want. In making that ruling, the Utah court had this passage that I would like to quote to this court. What the court said in Utah in affirming the freedom to marry was, quote, "It is not the Constitution that has changed, but the knowledge of what it means to be gay or lesbian," close quote. With that passage, the Utah Federal District Court made clear that the constitutional guarantee we all understand. It affirms the freedom to marry, it affirms equality under the law. But what's challenging sometimes for a court and for a society is to see how the Constitution's command applies to the members of the community, the citizens who are gay or lesbian. It requires this court now to understand the common humanity of gay and lesbian Colombians, and therefore to apply the Constitution's command to these people, to these citizens, with full dignity, full equality, and full freedom under the law. When this court does that conscientiously, as is its constitutional duty, this court should therefore rule in favor of the freedom to marry forthwith, and the majority will then come along. In societies like Colombia and like the United States, while we want public support, while we believe generally in majoritarian rule, we also believe there are certain guarantees, certain assurances that the society and the law make to everyone, even when unpopular or in the minority. This is such an instance, and it is time for Colombia's court to do the right thing under the Colombia Constitution by its citizens, and the public, as in the United States, will embrace it. Thank you for the opportunity to testify.